So before we get started, I do want to touch on a couple things here real quick. We haven't been in the building for a long time. We're now back, but I think we've gotten lazy on some of the rules. So we need to tighten up on the rules again, like no phones, nobody talking on phones during session.
Can we text?
What?
Can we text?
You can text, but you cannot talk and turn your ringers off. We're all supposed to have suit coats on when we're on the floor. We have cameras that are watching us right now. They're all centered on you guys, so behave accordingly. I don't want to see a full course meal on your desk. If you have snacks and a soda or something, that's one thing, but let's not bring dinner, okay? All those things don't look very good. They don't look very professional, okay? And I know there was one else. I'll think of it somewhere tonight, and I'll let you know then. So, Mr. Puffer, do we have any reports?
Yes, Mr. Speaker. Excuse me. Senate communication dated June 23rd, 2021. Mr. Speaker, the Senate wishes to inform the House that it has passed Senate Bill number 184 with Senate Amendment 2 and Senate Bill number 191 and requests the concurrence of the House. And the Senate has passed House Bill number 24, House Bill 32 with House Amendment 1, House Bill 48 with House Amendment 1, House Bill 81, House Bill 104, House Bill 112 with House Amendment 2, and House Bill 171, and is returning the same to the House. Mr. Speaker, House Committee reports for June 23rd, 2021 from Transportation, Land Use, and Infrastructure. Senate Substitute 1 for Senate Bill 157, 3 favorable, 3 on its merits. Senate Bill 142, 3 favorable, 3 on its merits. And Senate Bill 152 with Senate Amendment 2, 3 favorable, 3 on its merits. Mr. Speaker, this concludes reading of the communications.
Thank you. I do remember what the other item was. The rules say you stand to be recognized. Once I recognize you, can sit back down. We've gotten in the habit of standing there and going, or sitting down and going like this. I can't see that all the time. So stand up. I'll recognize you. You can sit back down until I call you. Okay? Thank you all. Representative Longhurst.
Thank you, Mr. Speaker. I move that we adjourn the current legislative day.
That's right. Straight language. House stand adjourned. House, please come to order. Ms. Clerk, please call the roll.
Mr. Bomback. Present. Mr. Bomback, present. Ms. Benz.
Yeah, present.
Excuse me, Mr. Bennett. I'm sorry. Screwed that one up. Mrs. Bennett, present. Mr. Benz, present. Ms. Bolden.
Present.
Ms. Bolden, present. Mr. Brady. Mr. Brady, present. Mrs. Briggs King. Mrs. Briggs King, present. Mr. Bush. Present. Mr. Bush, present. Mr. Carson. Present. Mr. Carson, present. Mr. Chicocha.
Yes, present.
Mr. Chicocha, present. Mr. Collins.
Present.
Mr. Collins, present. Mr. Cook. Present. Mr. Cook, present. Mrs. Dorsey Walker.
Present.
Mrs. Dorsey Walker, present. Mr. Dukes. Mr. Dukes, absent. Mr. Gray. Present. Mr. Gray, present. Mrs. Griffith. Present. Mrs. Griffith, present. Mrs. Heffernan.
Present.
Mrs. Heffernan, present. Mr. Hensley. Mr. Hensley, present. Mrs. Johnson.
Present.
Mrs. Johnson, present. Mr. Kowalko.
Present.
Mr. Kowalko, present. Mr. Lambert. Present. Mr. Lambert, present. Mrs. Longhurst.
Present.
Mrs. Longhurst, present. Mr. Lynn.
Present.
Mr. Lynn, present. Mr. Matthews. Mr. Matthews, present. Mrs. Minor Brown.
Present.
Mrs. Minor Brown, present. Mr. Mitchell. Present. Mr. Mitchell, present. Ms. Moore.
Present.
Ms. Moore, present. Mr. Morris.
Present.
Mr. Morris, present. Mr. Morrison.
Present.
Mr. Morrison, present. Mr. Osinski.
Present.
Mr. Osinski, present. Mr. Postles. Mr. Postles, present. Mr. Ramon. Mr. Ramon, present. Mr. Short. Mr. Short, present. Mr. Shoup. Mr. Shoup, present. Mr. Smith. Mr. Smith, present. Mr. Smick. Mr. Smick, present. Mr. Spiegelman. Mr. Spiegelman, present. Mr. Vanderwyn.
Present.
Mr. Vanderwyn, present. Mrs. Williams.
Present.
Mrs. Williams, present. Mrs. Wilson Anton. Mrs. Wilson Anton, present. Mr. Yerrick. Mr. Yerrick, present. Mr. Speaker.
Present.
Mr. Speaker, present. Mr. Speaker, the roll call reveals 40 present, 1 absent.
Quorum being present, House Representatives formally in session. The prayer for the day will be offered by Representative Bill Carson.
Thank you, Mr. Speaker. Bow our heads in prayer. Most holy and glorious Lord God, the great architect of the universe, the giver of all good gifts and graces, thou hast promised where 2 or 3 are gathered together in thy name, thou wilt be in the midst of them and bless them. In thy name we now assemble, humbly beseeching thee to bless us and our present assembly, and to illuminate our minds and may we walk in the light of thy countenance. And dear Heavenly Father, we ask you to send a special angel out to look over our brave troops wherever they may be serving to protect the liberty and freedom we all enjoy so much. God bless our country, our people, and all the good things that they stand for. Amen.
Before we go to the pledge, I'd like to go to Representative Heffernan for a moment of silence.
Thank you. Thank you to all my colleagues wearing green, teal, and pink this morning. It's for a good reason. Every year, 200,000 Americans are diagnosed with breast cancer. Out of this group, only 6 to 10% get the devastating news that their breast cancer has metastasized to stage 4. There is no cure, and average survival is just 18 to 24 months. We want to make sure that metastatic breast cancer gets the attention deserved and the research. I read this because Erica Wright, a wife, mother, and fierce metastatic breast cancer advocate, lived in North Wilmington in my district with her husband Joseph and her 6-year-old daughter Isabel, died on May 7th. Erica taught us that it's not how much time you have, but what you do with the time that counts. In 5 short years since her diagnosis, she not only raised thousands of dollars for metastatic breast cancer, but she also started a local support group for women in Delaware, PA, and New Jersey with metastatic breast cancer. She knew how important it was to tell her story. So despite that she hated public speaking, she took every chance she had to raise awareness. And in fact, her story was frequently featured in the news, including an Emmy Award-winning segment by NBC 10. She was also very active in MetaViver, which is the only organization that funds metastatic breast cancer. October 13th, 2021 is Metastatic Breast Cancer Awareness Day, and I encourage all my colleagues to continue Erica's fight to raise awareness. And so to Erica's family and friends, we want you to know that her advocacy continues and she is remembered here in Delaware. And to all the metastatic breast cancer survivors, we see you and we hear you and we'll continue to fight for you. And therefore, I ask for a moment of silence for Erica Wright.
Moment of silence for Erica Wright. Thank you. Please join me in the Pledge of Allegiance to the American flag.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The minutes of the previous legislative day have been posted. Without objection, be accepted as posted. Mr. Puffer, do you have any communications?
Yes, Mr. Speaker. Communication from the Honorable Timothy D. Dukes, dated 24th of June, 2021. The Honorable Peter Schwarzkopf, Speaker of the House, Legislative Hall, Delaware, Dover, Delaware, 19901. Dear Speaker Schwarzkopf, please be advised that it is necessary for me to be absent from legislative session this week on Thursday, June 24th, due to personal reasons. Thank you for your understanding. Sincerely, Timothy D. Dukes. Mr. Speaker, committee reports dated June 24th, 2021 from Labor, Senate Bill 181, 11 favorable. Senate Bill 184 with Senate Amendment 2, 4 favorable, 7 on its merits. From House Economic Development, Banking, Insurance, and Commerce, Senate Bill 175, 7 on its merits, and Senate Bill 102, 7 on its merits. Mr. Speaker, this concludes the reading of the communications.
Thank you. Representative Longhurst.
Thank you, Mr. Speaker. At this time, we're going to go to the agenda, item number 1, Senate Substitute 1 for Senate Bill 7. May I have it read in for the third and final time and brought before the House?
Yes, you may. Mr. Clerk, please read in Senate Substitute 1 for Senate Bill number 7, title only.
Mr. Speaker, Senate Substitute number 1 for Senate Bill number 7, sponsored by Senator Mansavinos and Senator Hansen and Senator Townsend and Senator Pettyjohn, and Representative Longhurst and Representative Chakwocha and other senators and representatives. An act to amend Title 11 of the Delaware Code relating to bail. Mr. Speaker, this includes the third and final reading of Senate Substitute Number 1 for Senate Bill Number 7 as amended by Senate Amendment 2.
I'll get you
And
in
Senate
there.
Amendment 1. Sorry.
Representative Wilson Anton?
No,
No, wait.
I'm
she's-
back. Oh,
No, she's saying it for a reason. I'm not.
I might be out of order. I have some amendments.
Okay, we'll get to you. You're way down the list, though. I got all these in front of you. We got to take them by order and ascending order. I do have a pre-filed amendment by Representative Bomback. I understand you want to strike this.
I do want to strike this based on conversations I've had. Thank you.
Thank you. House Amendment Number 1, the Senate Substitute Number 1 for Senate Bill 7 is hereby stricken. Representative Lynn, I hear you have a House Amendment Number 2 pre-filed. Did you want to strike that?
Yes, Mr. Speaker.
House Amendment Number 2 to Senate Substitute Number 1 for Senate Bill Number 7 is hereby stricken. Representative Lynn, you have House Amendment Number 3, same thing?
Yes.
House Amendment Number 3 to Senate Substitute 1 for Senate Bill Number 7 is hereby stricken. House Amendment Number 4 is pre-filed. Representative Longhurst, would you like to have it read in?
I may. Yes, may. Yes, please.
Ms. Puffer, please read in House Amendment Number 4 to Senate Substitute Number 1 for Senate Bill Number 7.
Mr. Speaker, House Amendment Number 4 to Senate Substitute Number 1 to Senate Bill Number 7, sponsored by Representative Longhurst. Mr. Speaker, this includes the reading of House Amendment Number 4 to Senate Substitute Number 1 to Senate Bill Number 7.
Representative Longhurst, House Amendment Number 4 to Senate Substitute Number 1 for Senate Bill 7 is now before us.
Thank you, Mr. Speaker. This question came up in the Senate, and they answered it pretty thoroughly, but with the conversation I had with Representative Spiegelman, he just wanted clarification. So this is a friendly amendment that just clarifies that in any case where a court sets bail for a single offense, the court shall require the defendant to relinquish, not forfeit, any firearms in their possession. Representative
Spiegelman.
Thank you, Mr. Speaker. Privileged to address the amendment sponsor.
Granted.
Thank you, Representative Longhurst. Your indulgence in this matter is much appreciated. Thank you.
Yeah. Thank you. Voice vote, please.
Excuse me, I'm losing my voice. All in favor of House Amendment Number 4 to Senate Substitute Number 1 for Senate Bill Number 7, signify by saying aye.
Aye.
Those opposed? Ayes have it. House Amendment Number 4 is, excuse me, true. It's declared passed the House and attached to the bill. We have House Amendment Number 5. I understand, Representative Wilson Anton, you have House Amendment Number 5 you want to strike?
Yes.
House Amendment Number 5 to Senate Substitute 1 for Senate Bill Number 7 is hereby stricken. And do you have an amendment number 6?
Yes.
Please present your amendment.
Which one is this? Are we doing it? It'll take a second.
Thank you.
Absolutely. There you are, young lady. Thank you. Where is this place at? Are you doing this? Yeah, I'm gonna go. Where is it?
Number 6.
I don't know why I think I'm gonna get out of here.
Mr. Puffer, please read in House Amendment Number 6 to Senate Substitute 1 for Senate Bill Number 7.
Mr. Speaker, House Amendment Number 6 to Senate Substitute Number 1 to Senate Bill Number 7, sponsored by Representative Wilson Anton. Mr. Speaker, this concludes the reading of House Amendment Number 6 to Senate Substitute Number 1 to Senate Bill Number 7.
Thank you. Representative Wilson Anton, House Amendment Number 6, Senate Substitute Number 1 for Senate Bill Number 7 is now before us.
Thank you, Mr. Speaker. I understand the intent behind Senate Substitute 1 to SB 7, but I am worried that the current language will lead to increased disparities in our criminal justice system based on socioeconomic status. The way that the bill is written, a defendant needs to have an attorney present in order to get secured bail. My amendment takes that hurdle away. It breaks the barrier in the case the defendant does not have an attorney. Most people would not know that this is their right, the way that it is drafted currently. This amendment solely is focused on making sure that the bill is not implemented in a way that is disproportionate. What do I do?
You'd like a vote?
Roll call vote, please.
Ms. Clerk, please call the roll on House Amendment number 6, Senate Substitute number 1 for Senate Bill number 7.
Mr. Bomback? Yes. Mr. Bomback, yes. Ms. Bennett? Ms. Bennett, no. Mr. Bentz? Mr. Bentz, yes. Ms. Bolden?
Yes.
Ms. Bolden, yes. Mr. Brady? Mr. Brady not voting. Mrs. Briggs King? Mrs. Briggs King, no. Mr. Bush? No. Mr. Bush, no. Mr. Carson? No. Mr. Carson, no. Mr. Chikwocha?
No.
Mr. Chikwocha, no. Mr. Collins?
No.
Mr. Collins, no. Mr. Cook? No. Mr. Cook, no. Mrs. Dorsey Walker?
No.
Mrs. Dorsey Walker, yes. Mr. Duke's absent.
No.
Pardon me.
No. Sorry.
Mrs. Dorsey Walker from yes to no, voting no. Mr. Duke's absent. Mr. Gray? No. Mr. Gray, no. Mrs. Griffith? Mrs. Griffith, no. Mrs. Heffernan?
No.
Mrs. Heffernan, no. Mr. Hensley? Mr. Hensley, no. Mrs. Johnson? No. Mrs. Johnson, no. Mr. Kowalko?
Yes.
Mr. Kowalko, yes. Mr. Lambert? No. Mr. Lambert, no. Mrs. Longhurst?
No.
Mrs. Longhurst, no. Mr. Lynn?
Yes.
Mr. Lynn, yes. Mr. Matthews? Mr. Matthews, no. Mrs. Minor Brown?
No.
Mrs. Minor Brown, no. Mr. Mitchell? Mr. Mitchell, no. Ms. Moore? Ms. Moore, yes. Mr. Morris?
No.
Mr. Morris, no. Mr. Morrison?
Yes.
Mr. Morrison, yes. Mr. Osinski?
No.
Mr. Osinski, no. Mr. Postles? Mr. Postles, no. Mr. Ramon? Mr. Ramon, not voting. Mr. Short? Mr. Short, no. Mr. Shoup? Mr. Shoup, no. Mr. Smith? Mr. Smith, no. Mr. Smick? Mr. Smick, yes. Mr. Spiegelman? Mr. Spiegelman, no. Mr. Vanderwin?
No.
Mr. Vanderwin, no. Mrs. Williams?
No.
Mrs. Williams, no. Mrs. Wilson Anton?
Yes.
Mrs. Wilson Anton, yes. Mr. Yerrick? Mr. Yerrick, no. Mr. Speaker?
No.
Mr. Speaker, no.
Hold on, I got Representative Brady,
From not voting to voting no.
Mr. Brady, from not voting to voting no.
Representative Ramon,
From not voting to voting no.
Mr. Ramon, from not voting to voting no.
Representative Smick,
From yes and no.
Mr. Smick, from yes to voting no. Mr. Speaker, the roll call reveals 8 yes, 32 no, 1 absent.
having failed to receive the required number of votes, House Amendment number 6, Senate Substitute number 1 for Senate Bill 7 is declared failed in the House. Representative Longhurst, we now go to the bill. Senate Substitute number 1 for Senate Bill number 7 is amended by Senate Amendment 1, Senate Amendment 2, and House Amendment 4 is now before us.
Thank you, Mr. Speaker. This bill creates a presumption of detention through the use of high cash bail only, set through a presumption of bail schedule in order to simulate preventative detention without the state constitutional change. Several Class A felonies, other violent felonies, sex offense, firearm charges, and others will trigger the presumption that high cash bail will be set. Most initial bail hearings in Delaware are held with the defendant having not yet had access to an attorney, and frequently there is no prosecutor present. There is no discretion in the statute regarding what the strength of the evidence should be to trigger the presumption. There will be a racial impact statement prepared by the CJC in conjunction with the statute, and firearms are required to be forfeited for all of the signal offenses as condition of the bail as well. If any questions, roll call.
Mr. Clerk, please call the roll on Senate Substitute number, Representative Lynn.
Thank you, Mr. Speaker. Mr. Speaker, permission to make a statement and call witnesses.
Go ahead, yes.
Thank you. The Eighth Amendment guarantees us the right that excessive bail shall not be imposed. The Sixth Amendment gives us the right to a speedy trial. However, the sacrosanct cornerstone of the American justice system is that those accused of crimes are innocent until proven guilty. Yet, despite that fact, because of bills like this, 3 out of 5 people in U.S. jails today have not been convicted of a crime. 500,000 people right now sit behind bars who are still presumed innocent. Defendants' inability to pay cash bail has led to a staggering growth in pretrial detentions. Cash bail, like the bail in this bill, disproportionately affects people of color, women, and those who have low incomes. It leads to unjust outcomes and post-detention disparities. But most importantly, it has little effect on whether a defendant will reoffend pre-trial. There is no greater assurance of public safety, but there is clear evidence that this disproportionately affects poor and people of color. When asked about his thoughts on cash bail and pretrial detention, the former Chief Judge of the New York State highest court, the Court of Appeals, stated, "Whether you're in jail for 3 days, 3 weeks, 3 months, or 3 years, it's an accelerator of human misery. You come out a changed man. The inability to afford even the most reasonable bail should not alone subject an individual to the detrimental impacts of detention. The cash bail system disproportionately affects low-income individuals. It exacerbates challenges they and their families already face, despite the fact that an individual's ability to front bail money has little impact on whether the individual is a risk to the community or the court." Which begs the fundamental question: why are we doing this? 2018 was the year immediately before the bail reform bill went into effect. 2019 was the year immediately after the bail reform bill went into effect. Specifically, the bail reform bill went into effect on January 1st of 2019. The Justice of the Peace Court maintains data that tells us how many defendants engaged in new criminal activity while on bail. This bill is designed ostensibly to prevent individuals who are out on pretrial detention from engaging in new criminal activity. Here are the actual facts about whether or not that happens. In Q1 of 2018, the year before bail reform, 22% of defendants engaged in new criminal activity while out on bail. The next year, 2019, 25% of defendants engaged in new criminal activity while out on bail. Quarters 2, quarters 3, and quarters 4 of 18 and 19 reflect the same or similar statistics, such that there was only a 2.75% average increase between 2018 and 2019 of defendants engaged in new criminal activity because of the bail reform bill. Simply stated, this narrative that bail reform has led to an increase in crime and or alternatively that individuals out on bail are engaged in new criminal activity in a way they were not before the new bail bill is simply that, a myth. It is not true. Here's what is true. The courts maintain data on the number of people charged with signal crimes, the list of 39 crimes that are in this bill. Between January of 19 and December of 19, one full calendar year, 5,517 people were charged with these signal crimes, the crimes that are enumerated in this bill. Of those 5,517 people, only 654 were convicted of those signal crimes. 600 out of 5,517 were found guilty. Yet, if this bill passes, all 5,517 people charged with these offenses would sit in a jail cell under the presumption of cash bail. What's even more concerning is that of those 5,517 people, 3,428 of them had their charges null-prossed or dismissed. So, this bill says that these 39 signal offenses are so horrible, so horrid, that we have to keep you in jail preventatively because we believe that you're going to go out and engage in new criminal activity. The facts do not bear that out. Of the 5,517 people charged with these crimes, 3,428 had those charges null-prossed, dismissed. 366 of those 5,517 people were found not guilty, or their charges dismissed, other than a null-pros. What does that mean? Well, that means that if this bill passes, 366 people who were found not guilty would be behind bars under the presumption of cash bail, even though they were innocent. What does this bill do to society? Does it ultimately help us? Citing a law review article from the University of Cincinnati, research shows that parents' imprisonment leads to negative outcomes for their children, including an increased propensity for violence, decreased school attendance, and increased anxiety and depression. The resultant effects of passing regressive bills like this means that we are creating the next generation of offenders, not preventing them. Jail destabilizes lives that are already unstable. It undermines the three most important things in all of our lives: steady employment, housing, and our family attachments. Most importantly, it directly leads to the loss of children. Without those support systems, people are more likely to get in trouble again. At this time, I respectfully call Lisa Mignatola from the Office of Defense Services.
I don't have her on my list for speakers.
I provided it to Ms. Wooten, Mr. Speaker.
All right, well, I got a list without her name on it. All right, Lisa Mignatola, are you out there? There you are, I see you.
And then, Mr. Speaker, my second witness will be Chief Judge Alan Davis.
Good afternoon.
Can you state your name and position for the record, please?
Lisa Mignatola, Chief of Legal Services for the Delaware Office of Defense Services.
Thank you. Good afternoon, Ms. Mignatola. Ms. Mignatola, what do you do for the Office of Defense Services?
My current position as the Chief of Legal Services, I am the main policy advocate for the office.
And Ms. Mignatola, how long have you been employed in that position?
12 years.
And Ms. Mignatola, in addition to serving in this position for 12 years, can you give us some background on your knowledge and extent and experience in criminal law in the state of Delaware?
I've been a criminal defense attorney with the Delaware Office of Defense Services for 25 years. I have tried cases in all courts in this state, and I have supervised multiple units before taking on the role as the Chief of Legal Services in 2009.
Thank you. Now, Ms. Mignatola, this bill has been described as to preclude firearm violence in the cities of Wilmington and the cities of Dover. Ms. Mignatola, are you familiar with Section 2107C of Title 11?
Yes.
What does that section say?
Section 2107C provides that notwithstanding any provision of this title to the contrary, a defendant who is charged with committing a violent felony involving a firearm or committing a violent felony while on probation or pretrial release has a presumption of a release bond guaranteed by financial terms secured by cash only.
Now, Ms. Mignotola, the rules of statutory construction, what does the inclusion of the word shall mean?
It means that is what the court must impose.
The court has to do this, is that correct?
Correct.
Now, is that the law today in the state of Delaware?
Yes.
So if I am arrested for committing a violent felony while on probation or pretrial release in the city of Wilmington, or I commit a violent felony involving a firearm in the city of Wilmington, will my pretrial release be secured by cash bail? Does that presumption exist?
Yes.
So, Ms. Mignotola, comparing what the law already is to this bill, do they not do the same thing? Is this already not the law of the state of Delaware?
It is the law of the state of Delaware with regard to the firearms offenses or with the violent felonies committed while on probation or on pretrial release. This bill extends it to a host of signal offenses that are not included within the definition of a violent felony involving a firearm.
Now, Ms. Mignotola, to your knowledge, does firearm violence still exist in the city of Wilmington, despite the presumption of cash bail right now?
Correct, it does.
Do people violate the conditions of their pretrial release right now, despite the presumption of cash bail?
Correct.
So can you tell me what this bill does, if anything, with regard to firearm violence in the cities of Wilmington or Dover?
This bill has the same presumption that has already existed in 2107C.
Now, Ms. Mignotola, I presume that you've done a bail hearing before, is that correct?
Correct.
Can you walk us through the process? So I'm arrested for a firearm offense. What's the first thing that happens to me? What is my first contact with the court?
You would have an initial appearance at the Justice of the Peace Court.
Do I have a lawyer for that hearing?
Generally, no. Unless you can afford your own attorney, there is not an attorney appointed at the Justice of the Peace Court hearing.
Okay, so for indigent people, people of low means, they do not have an attorney at their first contact with the court. Is that correct?
Correct. We currently do not staff those appearances.
Okay. And that's where bail is set. Is that correct?
That is where the bail is initially set. Correct.
How long until I'm in front of a judge again?
Your next appearance will generally be your preliminary hearing within the Court of Common Pleas. Per rules, it should be within 10 days of your arrest. Generally, it's somewhere between the 7 to the 10-day period when you would next appear for your preliminary hearing.
Okay. So somewhere between 7 and 10 days is what the rules prescribe before I'm in front of a judge after my first contact in JP court. Is that correct?
The rules prescribe within 10 days. In my experience, it's generally somewhere between 7 and 10 days when you have your first appearance in Court of Common Pleas for the preliminary hearing.
Now, if I could, and I'm sorry, I want to go back to that very first court appearance. There has been discussion that the JP court justice who gives you bail has some type of discretion, that under this bill, that it doesn't always have to be cash bail if you are charged with one of these signal offenses, that they could somehow deviate from that. Ms. Mignotola, in your experience, how often has a JP court magistrate diverged from a presumption?
I cannot give you specifics as to what the statistics are on that. What I can tell you is a presumption that would be very difficult for an individual who is representing themselves at the Justice of the Peace Court level to overcome. They have to rebut the presumption of cash bail by showing some type of mitigating evidence that they would not therefore be a flight risk or a risk to commit new offenses, something that's very difficult for a person who is representing themselves to do, and generally they would not be able to advocate for themselves to overcome that presumption.
Now, Ms. Minutola, 7 to 10 days later after JP Court, you're in front of a judge in the Court of Common Pleas. Are you afforded an attorney at that stage of the proceedings?
You are.
Okay. How often at that stage of the proceedings are bail modifications granted?
That really depends on the individual case. At that time, the attorney would have the ability to argue for a lesser bail. However, studies have shown that a person who is initially incarcerated tends to stay incarcerated throughout their pretrial period and have longer sentences and worse outcomes.
Now, Ms. Minutola, at that point, the defendant goes to yet a third court. Is that correct?
If the case is bound over at the preliminary hearing, it would go to the Superior Court.
Now, Ms. Minutola, when is the first contact that a defendant typically has with a lawyer before the Superior Court that will actually dispose of their case?
That varies widely. It depends on how long it takes for the grand jury to indict the case. So it could be 4 to 6 weeks before your case is indicted and transferred into Superior Court, although the attorney may be able to file a bail motion sooner than that.
Thank you. Now, Ms. Minutola, from beginning to end, arrest to disposition, how long does this process typically take?
Well, it depends on the nature and the seriousness of the charges, but generally, probably 6 months at least from start to finish in pre-COVID times. And the more serious charges, up to a year.
So conceivably, a defendant can be incarcerated for 1 year on charges that would ultimately be or could be null pros dismissed. Is that correct?
Correct.
From your experience with your clients, what is the economic and social impact of being incarcerated for 1 year?
Individuals who are incarcerated, even for 2 to 3 days, let alone 1 year, could lose their job, their housing, they're unable to pay their bills, they're unable to help participate in their own defense. So there are severe consequences for someone who is incarcerated in the pretrial period.
Thank you, Ms. Minutola. Just 1 or 2 more questions. Ma'am, are you familiar with bail schedules?
Yes.
What is a bail schedule?
A bail schedule is a schedule that basically assigns a set monetary amount per the offense or per the nature of the offense.
Have bail schedules been found to be unconstitutional?
There has been litigation across the country in which bail schedules have been found to be unconstitutional, correct?
And Ms. Minutola, what are the similarities between SB 7 and bail schedules that have been found to be unconstitutional?
SB 7 requires that the financial terms be set within or above the guidelines that are established by the CENTAC Accountability Commission. Within the bail guidelines that have been promulgated, there is a list of the monetary ranges, and they are set per class of felony. So, for example, a Class D felony, which would include an offense like an assault second, which is one of the signal offenses, the bail guidelines are $2,500 to $10,000.
Thank you, Ms. Minutola. Ms. Minutola, I don't have any further questions for you, but other members of the House may. Mr. Speaker, depending on whether or not my colleagues have any questions for Ms. Minutola, I would respectfully call Chief Judge Alan Davis.
Ms. Minutola, you may be excused. Chief Davis?
I'm here, Mr. Speaker.
Please state your name and title.
Alan Davis, Chief Magistrate, Delaware Justice of the Peace Court.
Sure.
Thank you. Good afternoon, Your Honor. Your Honor, I just have a couple of questions for you. Is your court currently working on rules that would address the implementation of the 2019 bail reform bill?
Not just my court, but I am the chair of a committee of a judiciary committee that is working on new rules.
And Your Honor, how long have you been working with your committee to address some of the concerns with the 2019 bail reform bill and the rules of the courts?
So the rules, the original rules were always dubbed interim rules. The intention was to begin developing new rules at the beginning of 2020. As we started that process, obviously the world turned upside down. It was paused until about the fall. And the co-chair of this, Judge Wallace from the Superior Court, and I reconvened in the fall with all of the stakeholders and came up with a set of new rules, and they were sent out for some discussion in the early part of this year, and with the hope that the Chief Justice had asked us to implement them by the end of June.
Now, Your Honor, Mr. Chief Justice, when are the new rules set to take effect?
The Chief Justice has asked us to pause for two reasons. First is this legislation, to see what the effect is going to be of this legislation. The second is he has convened a group to look at domestic violence and bail issues, because domestic violence is a particularly tricky issue or type of criminal activity that is not properly addressed under a number of areas. That report is due in September, and I would expect that we would have new rules sometime shortly after that.
Now, Your Honor, prior to this bill being introduced, was there any discussion with your committee at the courts about SB 7, or that this bill would usurp the work that your committee and the courts have been doing?
This bill came out at about the same time that the newly proposed rules came out. I think I got 6 hours of notice before it was introduced.
And Mr. Chief Judge, do you believe that your new rules, the rules that your court and the other courts are about to adopt, do they address the concerns of SB 7?
Representative, I don't know that I can state with any definitive nature that it will address the concerns that are in SB 7. We knew that there are issues with the current system that we wanted to address. Some of those were that there are problematic cases, and we need to address those. If this bill is intended to do that, then I suppose they're trying to address the same issues. If they, I'm not in the mind of the sponsor, so I can't say. All I can say is we knew that the original rules were interim rules. We needed new ones because we didn't know how the system was going to work under the new set of rules.
Representative Lynn,
we monitored the data.
I would ask you to be very careful what you ask him in terms of this legislation that's pending. You're putting him in a really bad spot. He's in the judicial branch. He interprets these type of bills. He shouldn't have that much input in the creation of the bill. So please just be very careful about what you ask him, okay?
And lastly, Your Honor, has there been any, and let me preface this question by saying that it's my opinion that SB 7 is designed to address new criminal activity, individuals who are rearrested while out on pretrial bail. Has there been any measurable increase in the occurrence of new criminal activity between 2018, the year prior to bail reform, and 2019, the year after bail reform?
I can say that the data that you cited at the beginning of this discussion is data that was collected to monitor the system, and that that is correct, that at the time that those data were collected, that was the current situation.
Thank you, Your Honor. Your Honor, I don't have any further questions for you, but one of my colleagues may. Thank you, sir.
I don't see any questions, Mr. I'm sorry, Representative Moore?
I had some comments I wanted to make on the bill.
Well, is it for the judge?
Oh, no.
Judge Davis, thank you for stopping in. It's always good to see you, and you're going to be excused at this time. Thank you.
Mr. Speaker.
And just finally, colleagues, thank you for the indulgence. I know this was a long process. I appreciate you taking the time to listen to me on what is an important bill, something that my colleague J.J. Johnson worked on in his years here, something that I have been working on since I became elected to this body in 2014, which is dedicating almost my entire career to criminal justice reform. Looking at this bill, it sets us back. This bill will have proven deleterious effects on women, poor people, people of color. What is not proven, what cannot be shown through data, and what is demonstrably untrue is that this bill will do anything to curb firearm violence in Wilmington or Dover. That this bill will do anything to preclude individuals from committing new criminal activity while out on bail. This bill will not work. It is regressive, and I urge my colleagues to vote against it. Thank you.
Representative Moore.
Thank you, Mr. Speaker. I wanted to thank the sponsors of this legislation and other legislators for their dialogue on this bill. And I want to acknowledge their willingness to engage and discuss our concerns. I know that this bill was written to address public safety concerns in light of recent events. I've been very conflicted on supporting this bill. I do understand the concerns of most people affected by gun violence. Last summer, 2 of my former students were found shot in the head. As well, gun violence is increasing across the state, not just in the city, but the entire state, even in my district. However, I do not think this legislation addresses that concern appropriately. This legislation will harm Black and brown and low-income communities, and this is a step backwards from the important criminal justice reform and racial justice efforts we have all been working so hard on. For these reasons, I will be voting no on this bill. However, I am remaining committed to addressing the root causes of crime and working with you all when I produce legislation in January that will be expanding and fully funding pretrial services and community support systems. So thank you.
Representative Kowalko.
Thank you, Mr. Speaker. Privilege of the floor for a comment.
Granted.
Thank you. I just got off the phone, three or four phone calls I just had with Representative J.J. Johnson. I'm sure almost everybody in this chamber remembers J.J. Johnson, our former colleague, my good friend, and my mentor. And when I was talking to J.J., he said, I would appreciate if you'd quote me on the House floor. So I'm going to read a quote from J.J. I'm going to read it word for word. I'm shocked by this bill. I'm shocked by what it will do to all my efforts and the efforts of others to reform Delaware's criminal justice system. With passage of this bill, you can now forget about reductions in the prison populations. Put the cots back in the gymnasiums. This will not reduce violence, but it will increase the prison population and prejudge the innocent. And he goes on to say, this is the type of thinking, this is quoted from JJ, this is the type of thinking that got us into mass incarceration problems in the war on drugs. Now we've translated that flawed thinking into the same mindset that will lead us back into mass incarceration problems and the very specific that I include is, and the new Jim Crow. I don't know how many people remember the efforts, but I believe some of the bills to reform the bail were named after Representative Johnson. And no one can question his feelings of justice and justice reform for the people he represented and for the people of the entire state of Delaware. So I just want to introduce that statement from him. I feel that there's a man that has earned all of our respect. So thank you, Mr. Speaker.
Thank you. Representative Chuck Wosha.
Thank you, Mr. Speaker. Privilege of the floor, sir.
Granted.
And as my colleague represented and gave a quote from one of our esteemed former colleagues, I will do the same. The former first district representative, former mayor of the city of Wilmington, said to me just 2 days ago, after there was a 14-year-old murdered just feet from his home, called and said, we have to do something about these guns, these individuals in our streets with guns. It's those quotes that motivate me to support this bill. Since I was a member on city council, every day there's a report comes from our police officers. Every day I review it. If it involves guns, I take a screenshot. I have hundreds of these in my phones. And I was just looking over a few of them, and I heard the chief judge mention so often they're being held with secure bail, cash only. That unfortunately, that's not happening in my city. It's not. Every day we have Wilmington police officers doing their best, making gun arrests, and individuals are being turned right back around to our very community, right back around. The same individuals. We have last year in 2020, our Wilmington police officers made 307 gun arrests. And of them, 148 of them had prior arrests. Many of them had more than one arrest. One individual had 6 arrests. And this so far this year alone, as of June 13th, there were 150 gun arrests. And that number's up over 31% from last year. And the same thing, over 60% of those same individuals are being reconvicted on gun crimes. This is happening repeatedly, over and over. And we speak about what are we trying to do to truly, that this won't impact our community. With the greatest respect that I have for Representative Lynn, he mentioned a few words, and they struck me to my core. What word he said was about human misery. You want to see human misery? It's seniors. It's seniors, fearful, living under siege, a constant threat of violence. It's children who live right across the street from a playground and their parents won't let them go to it. It's 6-year-olds attending their first day of flag football practice, first day ever, brand new mouthpieces and brand new cleats, and so ready to enjoy this new experience and have that experience interrupted by gun violence fewer than 100 yards from them. That's the misery. That's the misery where our communities are under constant threat of violence, where my city has been constantly, for the past decades, ranked in the highest level per capita with murders and shootings. One of the deadliest cities listed for violence and guns against teenagers. That's my city. And yet I see my officers going repeatedly out every day trying to do the work. And we say there's a divide between our officers and the community. The divide begins when individuals from our community see individuals with firearms being arrested. Those same individuals come right back on the street. That creates a sense of why should I say anything? It's fear. I'm feared. This individual's gonna get right back out. So now we don't have individuals to step forward to be witnesses. We don't have individuals step forward to give statements, to provide information that can help us solve crimes. It all goes to the same thing, this same just revolving door of individuals just repeatedly being released back into our community. This bill will address that. This bill will address that. Our communities hand over every civic association meeting I attend. My mayor and my police chief and my sector commander, so often they speak of this 1% of our population. This is a very small group of individuals who are wreaking havoc on our entire city. Just this week, our attorney general talked about a gang that is in my very district, terrorizing, and all these indictments and charges. How many of those individuals are who we're talking about, who were arrested and let right back out on the street? And the sad part is, we're saying like we're doing a disservice. We're going to lock individuals up. The service that we're doing is that we're saving lives. We're saving lives because these individuals, if they're not the shooter, they will be the victims of the violence. That's what's being shown. That's what the data is showing in my community. That's what the data is showing. The data is showing it's these same individuals who are being repeat offenders and wreaking havoc on our city. They're taking the opportunities from our children to live happy lives. We're talking about this stabilized communities. It's this violence. It's this gun violence that is destabilizing our communities. We're not talking about certain sections. As I mentioned earlier, this latest shooting was in Harlan Park. Harlan Park, one of the most stable two-family homes, communities in the whole city of Wilmington. Right there in the middle, the heart of our district, connected to P.S. DuPont Middle School. This isn't just happening in areas of need. This is all over our city, and it's a challenge. And all we're asking is to support our Wilmington police officers in their work. Because if we support them, then our community will support them. The challenge is right now, there is a divide because our community sees these individuals being arrested and released right back to the community. That's what this bill addresses. I'm 100% in support of it because it will have a direct impact on the violence in my city. And I implore my colleagues to consider a 14-year-old young man who never had the opportunity to drive a car, never had his first job, riding a bike in between two schools in the middle of the day. A week earlier, two teens shot in the park I grew up in the middle of the day. A 12-year-old and a 16-year-old. That's what we're talking about. We're talking about trying to stop this gun violence. And the way we stop it is by stop letting individuals just run amok and control our community through fear of violence. Thank you, Mr. Speaker.
Thank you. Representative Dorsey Walker.
Thank you, Mr. Speaker, and thank you, Representative Chifolcha, for sharing what we endure on a daily basis in Wilmington. Representative Lynn, I sincerely appreciate what you desire to do and what you have done around criminal justice. And I've stood with you as it pertains to criminal justice reform. But I must share with all of you that the most recent serial killer, he lived in my district. He walked my streets. He stood outside of places where I go on a regular basis. He's on camera. He allegedly killed his own mother in Philadelphia. He allegedly killed the woman working at the T-Mobile in Representative Mitchell's district. He allegedly killed the woman at the Dunkin' Donuts in Philadelphia. And he allegedly killed one of my constituents on 3rd Street who did not bother a soul. This man walked around on hazy, hot, and humid days wearing a black hood. And my constituents, they were all calling me, you know what this guy is? I did not know. Until finally, he decided to rob the Rite Aid on 4th Street. Now, I can tell you, I probably would not have voted for this legislation. But maybe 2 weeks ago, I may not have voted for it. But upon finding out that this man lived in my district, walked amongst my constituents, people who I absolutely love, I consider my constituents family. And to know that he had committed murder and he came out and he was able to walk the streets freely, that's a problem for me. I reached out to Representative Chakwocha when I found out that we lost one of our babies, a 14-year-old riding his bike in the broad daylight. It had been raining earlier in the day. Sun shines on Wilmington. And one of our babies riding his bike in one of the most stable communities in the city, next to Bayard Square and Union Park Gardens. Our babies can't ride their bikes. That's a problem. Our children can't go to parks, as Representative Chakwocha mentioned. That's a problem. I'll say this to you. We know when a cop has been shot, and we know when children have been shot when we live in the city of Wilmington, because you hear helicopters all night long. That's not normal. We are living in trauma, what we endure on a daily basis from the gun violence. And our Attorney General is doing the best she can. Wilmington Police, Newcastle County Police, Police Department, all 48 policing departments up and down the state of Delaware are doing what they can, but they need help. And this is the opportunity to give them the help that they need. Thank you, Mr. Speaker.
Roll call.
I have Representative Wilson Anton.
We have taken great steps in the last few years towards meaningful criminal justice and bail reform, and this is an enormous step backwards. When I first began to work here in the legislature, members of the body, like Representative J.J. Johnson and Helene Keeley, were advocating for reforms to our unjust system. I was proud of the progress that I saw happening in front of my eyes. That's part of the reason why I stand here today, because I was inspired by their work. I hear the concerns of my colleagues about violence within our communities. They're legitimate concerns. My heart breaks for the victims and survivors of violence everywhere. But this bill does not address those concerns. It will likely have the opposite effect, as locking innocent people up leads to families losing income, housing, and spiraling into instability. As legislators, we have the responsibility to create laws that protect our communities and make us all safer and able to thrive, not just survive. We need to address the actual root causes of violence, and this bill does not do that. Make no mistake, we will look back at this as our 1994 crime bill. We can and should be held accountable for our votes on this bill and the legacy that it will have. I introduced an amendment with the hopes of improving the bill so that it's not as classist in its implementation, and that amendment failed. I'm unable to support the bill, and I urge my colleagues to vote no.
Representative Morrison.
Thank you, Mr. Speaker. So many of us, as we should, base our votes on evidence, numbers, statistics, critical thinking, and logic. Just yesterday, many of the same House members who may vote yes on SB 7 today voted yes on HB 212, banning plastic bags in Delaware. Those votes were based on numbers and evidence. And numbers and evidence were presented here on the House floor in support of HB 212 and were cited extensively in the bill's whereas clauses. In terms of evidence and numbers for SB 7, we have numbers from the Delaware Superior Court demonstrating that overwhelmingly individuals accused of the crimes listed in this legislation are either found not guilty or have their charges dropped. We have those numbers and we should pay attention to those numbers. But in all fairness, if everyone would be so kind as to turn around and look in my direction, I would also like to present the evidence and numbers we've received in support of SB 7. This is it, nothing. A number of us have repeatedly asked government entities, and individuals for evidence and numbers supporting this legislation, and this is what we have been given. Naturally, this leads me to believe that government entities and individuals either have no evidence and numbers to support this legislation, or they have those evidence and numbers that are contradicting support for SB 7, and therefore we will never see those numbers or evidence. This legislation will not make any of us safer in any significant way. It will do very little to prevent us from being victims of crime. What it will do is create a very large number of new victims. More victims of our horribly dysfunctional and broken criminal justice system. Many of them, as always, people of color and people of a lower socioeconomic status. And it will further contribute to our already atrocious mass incarceration problem. What this legislation will do is hold in prison many individuals who will later be found not guilty or have their charges dismissed. But while they are in prison, those individuals will lose income and may lose their jobs, their apartments, their homes, and their vehicles. And those individuals will be removed unnecessarily from their families, their children, and their communities. I will also say that I have heard from many constituents and Delawareans regarding SB 7. They have all asked me to oppose this bill. Not a single Delawarean or constituent has contacted me asking me to support it. This is indeed, as Representative Wilson Anton suggested, our 1994 crime bill that was put forth with good intentions but had horrible effects. We now look back and we know that. Let us not make that same mistake here in Delaware. Let us not have people in the future who support justice and equality look back on history and judge us as they will, and if we pass this bill, as they should. This is regressive legislation that undoes important progress we've made in criminal justice reform and on cash bail reform. I ask my fellow House members to please seriously consider the wonderful testimony from our witnesses, the very factual, evidence-based, logical remarks from Representative Sean Lynn and my other colleagues who have made similar remarks here today, and vote no on SB 7 as I will be doing. Thank you.
Roll call.
Thank you, Mr. Speaker. I just want to say I cannot for the life of me understand why we are running this bill at this stage of the session. If there are so many problems, or if there are not any problems, it would be better served to work this bill in January. Thank you.
Then Amy Brown.
Thank you, Mr. Speaker. You know, I wasn't going to speak on this bill, but I think I should. I want to share a conversation I had with my husband, who did 11 years in prison. This bill has weighed so hard on me. And I talked to my husband about it. And this is what he said to me. My husband was out on bail when he was rearrested, and he ended up spending 11 years in prison. 2 days ago, his 14-year-old mentee was shot in the head while riding his bike. A good kid. My husband said, if he didn't go to jail and stay in prison, he would be dead right now. and he knows that for a fact. My husband said, and this is I know we talk about minority communities. This is the Black man, the troubled youth, the troubled juvenile that spent 11 years in prison, who now works with troubled youth every single day. My husband said, you have to look beyond your front thoughts. You have to think about how this bill is actually saving the lives of our troubled youth, because they won't be shot dead in the street. When he went to Christopher's house 2 days ago and sat with his mother while she held her son's bloody socks in her hands after she washed the blood up in the middle of the street, my husband said, that would have been him. He didn't see it in the beginning. He said, it doesn't hit you till you're standing in court and they say, you're sentenced to 11 years. But as he sat there and reformed his life, he thanked God for that sentence. Because if he didn't have that sentence, his mother would be without a son. He would have been another life lost in the city, and I wouldn't have him as my husband. I just wanted to share that conversation that I had with my husband, the Black man, the troubled youth, who did 11 years in prison and is thankful for it because it transformed his life.
Thank you.
Roll
Representative
call.
Long. Mr. Clerk, please call roll. Senate Substitute Number 1 for Senate Bill Number 7 as amended by Senate Amendment Number 1, Senate Amendment Number 2, and House Amendment Number 4.
Mr. Bomback?
No.
Mr. Bomback, no. Ms. Bennett? Ms. Bennett, yes. Mr. Benz? Mr. Benz, no. Ms. Bolden?
Yes.
Ms. Bolden, yes. Mr. Brady? Mr. Brady, yes. Mrs. Briggs King? Yes. Mrs. Briggs King, yes. Mr. Bush? Mr. Bush, yes. Mr. Carson? Mr. Carson, yes. Mr. Chikwocha?
Yes.
Mr. Chikwocha, yes. Mr. Collins?
Yes.
Mr. Collins, yes. Mr. Cook? Yes. Mr. Cook, yes. Mrs. Dorsey Walker?
Yes.
Mrs. Dorsey Walker, yes. Mr. Dukes absent. Mr. Gray? Yes. Mr. Gray, yes. Mrs. Griffith? Yes. Mrs. Griffith, yes. Mrs. Heffernan? Mrs. Heffernan, yes. Mr. Hensley? Yes. Mr. Hensley, yes. Mrs. Johnson? Mrs. Johnson, yes. Mr. Kowalko?
On behalf of True Justice, Representative Kowalko is voting no.
Mr. Kowalko, no. Mr. Lambert? Mr. Lambert, no. Mrs. Longhurst? Yes. Mrs. Longhurst, yes. Mr. Lynn?
No.
Mr. Lynn, no. Mr. Matthews? Yes. Mr. Matthews, yes. Mrs. Minor Brown?
Yes.
Mrs. Minor Brown, yes. Mr. Mitchell? Yes. Mr. Mitchell, yes. Ms. Moore? Ms. Moore, no. Mr. Morris?
No.
Yes.
Mr. Morris, yes. Mr. Morrison?
We got to change those names. No.
Mr. Morrison, no. Mr. Osinski?
Yes.
Mr. Osinski, yes. Mr. Postles? Mr. Postles, yes. Mr. Ramon?
No.
Mr. Ramon, no. Mr. Short? Mr. Short, yes. Mr. Shoup?
Yes.
Mr. Shoup, yes. Mr. Smith? Mr. Smith, yes. Mr. Smick? Mr. Smick, yes. Mr. Spiegelman?
Yes.
Mr. Spiegelman, yes. Mr. Vanderwyn?
Yes.
Mr. Vanderwyn, yes. Mrs. Williams?
Yes.
Mrs. Williams, yes. Mrs. Wilson Anton? No. Mrs. Wilson Anton, no. Mr. Yarrick? Mr. Yarrick, yes. Mr. Speaker?
Yes.
Mr. Speaker, yes.
Representative Ramon.
No to yes, please, Mr. Speaker.
Mr. Ramon from no to voting yes. Mr. Speaker, the roll call reveals 32 yes, 8 no, 1 absent.
I received its constitutional majority. Senate Substitute Number 1 for Senate Bill 7 is amended by Senate Amendment Number 1, Senate Amendment Number 2, and House Amendment Number 4. It's declared passed. Representative Longhurst.
Thank you, Mr. Speaker. At this time, I'd like to go to Representative Sherry Dorsey Walker. I think she has a resolution she'd like to introduce.
Mr. Speaker, I'd like to call motion for suspension of the rules, please.
Give me a second.
Do we have it here?
It's been emailed out to everybody. Everybody should have.
It's Juneteenth.
Yes. House Bill
This is
number
a
House Bill
Juneteenth.
119, Juneteenth bill. Everybody should have it, right?
In our elementary and middle.
I got it.
So we just got to keep going.
We have a motion to suspend rules on House Bill 119. I need a second. We have it's been moved and second. Rules be suspended for action on House Bill number 119. Mr. Clerk, please read in House Bill number 119, title only.
Mr. Speaker, House Bill number 119, sponsored by Representative Dorsey Walker and Representative Bolden and Representative Chukwucha and Representative Cook and Representative Johnson and Representative Lambert and Representative Minor Brown and Representative Moore and Representative Wilson Anton and Senator Brown and Senator Lockman and other representatives and senators. An act to amend Title I of the Delaware Code relating to legal holidays. Mr. Speaker, this includes the third and final reading of House Bill number 119 by title only.
All in favor of suspending rules for action on House Bill 119, signify by saying aye. Aye. Those opposed? The ayes have it. Rules are suspended. House Bill 119 is now before us. Representative Dorsey Walker, the floor is yours.
Thank you, Mr. Speaker. This act establishes Juneteenth as a paid state holiday. Juneteenth commemorates the emancipation of the last enslaved blacks in the United States.
Representative Walker, I hate to stop you in the middle there, but we do have a pre-filed House amendment that snuck in here.
Wait a minute. There sure is, Mr. Speaker.
So, Mr. Puffer, please read in House Amendment number 1 to House Bill 119, title only.
Mr. Speaker, House Amendment number 1 to House Bill number 119, sponsored by Representative Dorsey Walker. Mr. Speaker, this includes the reading of House Amendment 1 to House Bill 119.
Representative Dorsey Walker, House Amendment number 1 to House Bill 119 is now before us. Just on the amendment.
Thank you, Mr. Speaker. The amendment states that Juneteenth will not be a floating holiday. It will be a permanent legal holiday in the state of Delaware. Voice vote, please.
All in favor of House Amendment number 1 to House Bill 119, signify by saying aye.
Aye.
Those opposed? Ayes have it. House Amendment number 1 is passed. It's now attached to House Bill 119, which is now before us. Now you can tell your story.
All right. Thank you, Mr. Speaker. This act establishes Juneteenth as a paid state holiday. Juneteenth commemorates the emancipation of the last enslaved blacks in the United States. This act adds Juneteenth as a permanent legal holiday. Juneteenth is the actual day of independence for Black people. When the Emancipation Proclamation was signed on January 1st, 1863, this still did not free the slaves fully. Many Black churches still celebrate watch night services on December 31st. My church, Bethel AME, does. That's when Black people waited in anticipation, praying and believing God that the signing of the Emancipation Proclamation would take place on January 1st, 1863. Due to the fact that the word had not traveled to Galveston, Texas, to inform the slaves that they were free citizens, Major General Gordon Granger of the Union Army informed 250,000 slaves they were emancipated. Juneteenth is the actual day of independence for Black people. While America celebrates July 4th for freedom, when the Declaration of Independence was signed, Blacks were still not free. But Juneteenth, June 19th, is the day that we actually had freedom. In actuality, Delaware ratified the Constitution December 7th, 1776, yet did not ratify the 13th Amendment until 36 years later on February 12th, 1901. My paternal grandmother was born August 10th, 1910. My maternal grandmother, April 27th, 1927. These two needed amendments in order to be able to vote in the United States of America. To contextualize this for you, both sets of my great-grandparents were slaves. This act will honor our ancestors and all the sacrifices they made to get us to this point. With the passage of this legislation, we shall indeed overcome. I would like to take a moment and just say a special thank you to our leadership and to those who have organized and participated in Juneteenth events throughout the state. Representative Lynn has been a stalwart as it pertains to Juneteenth and working with Reverend Rita Page in Dover. Representative Danny Short has been amazing in Seaford, working with AFRAM and Juneteenth. And Representative Stephanie T. Bolden, the longest serving African-American woman in the state of Delaware, does amazing work with Juneteenth. We'd be remiss if we did not honor her on this day. I would also like to take a moment to state that some asked, why would we need this when our president just signed legislation to make it a national holiday? I'll remind you that while Martin Luther King Day became a national holiday in 1983, Delaware did not start celebrating Martin Luther King Day until Representative Al O. Plant passed legislation in this body to make Martin Luther King Day a paid state holiday. This is indeed one of the advancements of the Delaware Legislative Black Caucus's Justice for All agenda. And I would like to just say a special thank you to Governor Cornyn, to Representative Carson, to our leadership, and to all the members of the House, because I thank you in advance for voting yes. And I'll acknowledge those. You'll see that I'm wearing my Howard University sweater in honor of my alma mater, HBCU. We have several members who are graduates of HBCUs. And those who are on the floor, I'll ask you to stand right now. We have Delaware State University represented, Cheney University, Lincoln University, and of course I mentioned HU. But I don't believe I forgot any of the schools. But with that, Mr. Speaker, I shall ask for a roll call vote.
I have Representative Collins
Yes, Mom.
would like to speak.
Yes, because my mom told me not to go.
Speaker, just like to make a short statement. First of all, I really want to thank Representative Dorsey Walker for bringing this forward. And there's no question that
Will continue to be. Tell her.
folks like myself, we don't understand everything about these matters. I want to thank some of the newer representatives, like Representative Dorsey Walker, for bringing a new level of understanding. And I will also thank Stephanie Bolden for the chicken she brought me today. Thank you for this, and I will be more than happy to vote for it.
Way to go, staff. Mr. Clerk, please call the roll on House Bill number 119 as amended by House Amendment number 1.
Mr. Baumbach? Yes. Mr. Baumbach, yes. Ms. Bennett? Yes. Ms. Bennett, yes. Mr. Benz? Mr. Benz, yes. Ms. Bolden?
Yes.
Ms. Bolden, yes. Mr. Brady? Mr. Brady, yes. Mrs. Briggs King?
Yes.
Mrs. Briggs King, yes. Mr. Bush? Yes. Mr. Bush, yes. Mr. Carson? Yes. Mr. Carson, yes. Mr. Chiquocha?
Yes.
Mr. Chiquocha, yes. Mr. Collins?
Yes.
Mr. Collins, yes. Mr. Cook?
Yes.
Mr. Cook, yes. Mrs. Dorsey Walker?
Yes.
Mrs. Dorsey Walker, yes. Mr. Duke's absent. Mr. Gray?
Yes.
Mr. Gray, yes. Mrs. Griffith? Yes. Mrs. Griffith, yes. Mrs. Heffernan?
Yes.
Mrs. Heffernan, yes. Mr. Hensley? Yes. Mr. Hensley, yes. Mrs. Johnson? Yes. Mrs. Johnson, yes. Mr. Kowalko?
Yes.
Mr. Kowalko, yes. Mr. Lambert? Mr. Lambert, yes. Mrs. Longhurst?
Yes.
Mrs. Longhurst, yes. Mr. Lynn?
Yes.
Mr. Lynn, yes. Mr. Matthews? Mr. Matthews, yes. Mrs. Minor Brown?
Yes.
Mrs. Minor Brown, yes. Mr. Mitchell?
Yes.
Mr. Mitchell, yes. Ms. Moore?
Yes.
Ms. Moore, yes. Mr. Morris?
Yes.
Mr. Morris, yes. Mr. Morrison?
Yes.
Mr. Morrison, yes. Mr. Osinski?
Yes.
Mr. Osinski, yes. Mr. Postles? Mr. Postles, yes. Mr. Ramon? Mr. Ramon, yes. Mr. Short? Mr. Short, yes. Mr. Shoup?
Yes.
Mr. Shoup, yes. Mr. Smith? Mr. Smith, yes. Mr. Smick? Mr. Smick, yes. Mr. Spiegelman?
Yes.
Mr. Spiegelman, yes. Mr. Vanderwyn?
Yes.
Vanderwyn, yes. Mrs. Williams?
Voting yes.
Mrs. Williams, yes. Mrs. Wilson, Anton? Mrs. Wilson, Anton, yes. Mr. Yerrick? Mr. Yerrick, yes. Mr. Speaker?
Yes.
Mr. Speaker, yes. Mr. Speaker, the roll call reveals 40 yes, 1 absent.
Item receives constitutional majority. House Bill number 119 as amended by House Amendment number 1 is declared passed the House. Good job.
Thank you.
Good job.
Thank you, everyone.
Thank you, everybody. Mr. Puffer, do you have some announcements?
Yes, Mr. Speaker, committee reports for June 24th, 2021 from House Administration, House Bill 191, 1 favorable, 3 on its merits, and House Bill 194 with Senate amendment, Senate, that's right. Sorry, these are Senate bills. Senate Bill 191 with 1 favorable, 3 on its merits, and Senate Bill 194 with Senate Amendment 1, 4 on its merits. Mr. Speaker, communication from the Senate. Senate wishes to inform the House that it has passed Senate Concurrent Resolution number 61 and requests the concurrence of the House, and it has passed House Bill 250 and House Bill 251 and House Bill 57 with Senate Amendment 1 and House Joint Resolution number 5 and House Joint Resolution number 6, and is returning the same to the